Hi, welcome back to the Special Committee on Impeachment Inquiry this Wednesday afternoon, September 20th. And we are next going to hear from Deputy Director Christopher Brickell from the Vermont Criminal Justice Council, who will talk a bit about the professional regulation process for use of force. So over to you, Deputy Brickell. Thank you for being here.
Thank you for having me this afternoon. I appreciate the opportunity to bring some information to the committee, and happy to entertain any questions once I give you a breakdown on how the Act 56 process works related to use of force. So let me first begin by saying, as you're well aware, Act 56 became effective July 1st of 2018. And what it did was it identified the process of unprofessional conduct of law enforcement officers, how cases are identified, how they're investigated, and processed by the Vermont Criminal Justice Council. And the council, in an effort to process those, developed and adopted their own procedures by which they process the complaints. So the first point might be, how do we receive complaints and how do they come to the council? Well, it's important to note that complaints are accepted from any source and in any form by the executive director. So we typically get complaints from several different sources, but we get complaints that are received by the council itself. So they'll come directly to us. They can come by email, by phone. We have other complaints that are received by the agencies, and that's really the most common referral of complaints that we get when an officer is under investigation for some sort of complaint. That's when we typically get notified from the agency. And then complaints are also coming in through sometimes media reports. Staff or council members see things out in the public or hear things that are reports that may not have been referred to us yet. So they ask us to check into those things. And then the basis of any unprofessional complaint can range from an allegation of criminal behavior. It could be a violation of a statewide policy, an agency's policy, or a council policy, rule, or process. So once we get the complaint, we have to receive it, and then it's accepted by the executive director. And then the complaint typically is referred to the agency where the officer is being accused for them to complete an internal affairs investigation of the allegation. And that agency, depending upon their resources, may seek out the assistance of another agency to complete the internal investigation for them. And that could be just due to lack of resources or to avoid a conflict of interest. There are agencies that help each other out to help accommodate those internal affairs investigations. And then the agency, once they're completed with the internal affairs investigation, they send that to the council, and that gets reviewed by our professional regulations subcommittee. And what happens is the subcommittee takes all of the evidence together that they get from the internal affairs investigation, which includes audio files, video files, written statements, officer reports, anything and everything that goes into an internal affairs investigation. And then they review that process, and they make a determination based on the evidence that they see. In certain circumstances, in limited circumstances, the council itself will conduct its own investigation. And that would typically be in the case where the complaint involves either a council process that has been allegedly violated, or if the complaint is about the agency executive themselves. So clearly they can't investigate themselves, and a valid investigation is identified in the statutes so that anybody with an effective internal affairs investigation process has to follow that process. And if the agency head is the source of that complaint, then they cannot investigate themselves. So that would be a council process investigation. Starting with the professional regulation subcommittee, who is that and what do they do? They are a group of 5 members of the council. The council consists of 24 people, and that 5-panel person is, or the 5-panel subcommittee is appointed by the chair of the council, and they all come from diverse backgrounds. And the members that are currently on the Professional Regulations Subcommittee represent different seats of the council. So one member is the representative of the Vermont Leagues of Cities and Towns. One member is a representative of the Vermont Association of Chiefs of Police. One member is the member who represents the Vermont Network Against Domestic and Sexual Violence, and then 2 governor-appointed members of the council. So that's the 5-member makeup. And then what happens with that is once they have reviewed those complaints, the members of the subcommittee are not allowed to participate in any potential future council hearing regarding any potential sanctions, because they have clearly already seen the evidence, and then they've made the decision and voted to send it to the council, so they cannot participate in that process. So specific to use of force complaints and what happens with them through the subcommittee, what happens is the members will review the completed internal affairs investigation, and they'll review all documentation, reports, statements, audio, video files. If there is a criminal investigation associated with it, they review that as well. And then the members themselves vote to determine if there was a violation of the state's use of force policy. Now, having said that, what happens is sometimes investigations take a bit before they can be reviewed, because sometimes when there is a criminal investigation, agencies may either elect to run a internal affairs investigation at the same time as the criminal investigation, or they may choose to wait until the criminal investigation is completed. That's up to them. But either way, once the committee has the information for themselves to review, they don't have to wait for any review of any criminal investigation to be completed. Once they do review all those files and the evidence is presented to them, if they find that there is a violation, then that complaint about the use of force policy violation is sent to the council to schedule a hearing regarding the officer's certification and potential sanctions. And while that hearing is being scheduled, that subcommittee can also work through assigned counsel to reach a stipulated and consent agreement with the officer for the council to review. So it would be similar to for instance, a criminal case where there are discussions ongoing and there is a plea agreement reached, and that still has to be agreed upon by both sides and the judge. It's similar to a council process by which the Professional Regulations Subcommittee sends the facts to the council for them to have a hearing. The officer is allowed to be present at the hearing, be represented by counsel. The hearings themselves are public by nature, short of the deliberation by the council after they've heard the evidence. And once that takes place, that hearing will conclude, and then the council will review all that evidence and they render a decision that includes findings of fact and sanctions that might be imposed upon the certification of the officer. If an officer is found to have committed unprofessional conduct, the council has one of 4 options by which to sanction an officer. One is by a written warning. The second is by a term of suspension, but that suspension has to be concurrent with whatever suspension they were administered by their agency. The third sanction is for a suspension of certification with the opportunity to reapply for certification. And then the fourth is permanent revocation of their certification. And for any officer that has been found guilty of unprofessional conduct where they've had any sanction imposed by the council, they have the ability to appeal that to the Vermont Supreme Court if they're not happy with that decision. So that's kind of an overview of the process and how it plays out. I'm happy to entertain questions relative to how I've explained that or any others that relate to the professional regulation process.
Questions for the committee?
Yeah, Representative Brannigan.
How many of these do you do a year?
Per year, I can't give you a total number. I just looked earlier today, starting from July of 2018, and there have been a total complaints referred to us of 183. Now, that doesn't mean that they all meet the criteria to be a valid complaint, but that's the number that has come to us in that time frame.
So that would be, did I do this right, 5 years to 50 or 60 a year?
Approximately, yes. And those are not just use of force complaints. Those are unprofessional conduct complaints.
Okay. Thank you.
Senator Dolan.
Yes. Thank you for this information about the sanctions. I'm wondering if you can share more about how or what would inform which sanction you would choose. Like how do you go from a warning to suspension? You know, how do you choose those different ones? What are the factors?
Well, that's a good question because as of this date, the council has not had a contested hearing as of yet. So there hasn't been a determination by the council as to what sanction they would take. There have been numerous stipulated agreements that have been reached between the subcommittee and the subject officer that have been ratified by the council. And the majority of those have been for permanent decertification. That is determined essentially by the members of the subcommittee. When they review the evidence and what the issues are that have been alleged to have been committed, you know, they see and hear the evidence and they take all of those actions into consideration. And it's the mindset of those that are actively or formally involved in law enforcement and those community members that actually decide what they feel is the appropriate sanction that officer should face.
I might not have followed all of that. So you're saying you haven't gotten to a place where the council has had to determine what a sanction was because agreements were already created that were presented to the council.
That's correct. That's correct. As far.
And I think I also heard that, I don't know if it was all, but it sounds like most of those, it is the permanent decertification is what was proposed.
That was the agreement that was reached between the professional regulation subcommittee and the involved officer. But again, even though that stipulation agreement can be reached, that still gets presented to the council. They still have to ratify that. They can send that back for, you know, additional review. If they don't agree with the agreement, they can take any number of actions.
Okay. And you also mentioned that that stipulated agreement is kind of like a plea bargaining process.
I'm trying to reference it in a way that most people would understand what a stipulation and consent order is. It's very similar to when you see somebody charged with a crime, but they plead to something different. How it's unique in our process in that a stipulated agreement is very much like a plea agreement where the facts are laid out, but maybe not all of the entire facts of the case. And there are sometimes reasons for that happening. But the council in past practice has made it very clear to the professional regulations subcommittee that they want to know as many facts as they possibly can, even though it might be a stipulated agreement. So what has been happening in practice is that prior to a potential stipulated agreement being drafted, a notice of hearing gets sent to the officer so that they're aware that there is a potential hearing coming up. And in that notice of hearing is pretty much detailed all of the factors that involved in what the subcommittee reviewed and the findings that they found, so that the officer as well knows the evidence that's going to be presented to them at a hearing.
Okay, this is helpful because I'm trying to understand what would be the benefit of doing the stipulated agreement if it automatically includes the worst sanction, but it's the fact that with the subcommittee, information is confidential, and once it goes to the council, it is now public information, and so you might come up with an agreement that doesn't make all of the information public, but you still could have the worst sanction.
That's true. However, the notices of hearing that I just described that pretty much lay out all of the factors that would be presented as evidence are also public documents and posted on our website. So that's public information as well.
What is the advantage of doing the stipulated agreement? Maybe I'm missing something.
I think in sometimes it's the the officers not wanting to appear in public and have all of their dirty laundry aired out in some cases. In some cases, it's to minimize the impact that it might have on victims in an associated policy violation where an officer might want to have that victim testify. So there are a number of factors that go into those decisions.
Thank you.
So just to follow up just about the numbers, you're saying about 50 complaints a year, then some number of those presumably, I'll use the word substantiated, they're not substantiated. And then the rest go generally so far at least to a stipulation. Is that about right? And I guess the question I'd have as well is how many of these complaints are actually upheld and actually lead to a stipulation?
Well, I think currently all of the cases that the subcommittee have reviewed and sent to the council for a potential hearing have reached a settlement. Some are still pending. There are several cases that are still awaiting the files from the agencies to be completed for them to review. So I would say right now, the cases that have come before the council, whether it's been through a notice of hearing or a stipulated agreement, those have all, with the exception of, I believe, one or two, reached a permanent revocation status.
And about how many of those have occurred? I mean, how many stipulations are there of the approximately 50 complaints a year?
Currently, right now, from the beginning of the trackings from July of 2018, I would say that there are, I believe, 7 or 8 stipulated agreements that have reached final conclusion.
So not that many relative to the number of complaints necessarily.
Correct. And so one other thing I didn't mention to you in the process that might shed a little light on that is that the council statutorily is required to meet quarterly due to the amount of business and activity that the council is involved in. They actually meet monthly, and they set 2 dates for the month, one for a council meeting and one they schedule for a potential hearing. So the subcommittee that reviews all of these cases, they actually meet bi-weekly, and they do that, and they typically look at between 3 and 5 cases per meeting. And that entails all those files to be reviewed by them, then them having the meeting, discussing those cases, and then voting them out. And then those votes out go to the council. So the council has basically set up one date per month to have either a potential hearing or a stipulated agreement to review.
So just a question about the hearings themselves, and maybe you've mentioned this and I missed it. So do the hearings, are they evidentiary? Are they based on the investigative report completely, or do you bring in the witnesses? Tell me a little bit more about what the actual hearing would look like if you ever get to one.
So the council hearing itself would be it's a public hearing, open to the public. Is typically done by, it would be our Associate General Counsel, who you met earlier today, Kim McManus. She would be the prosecutor, so to speak. And then we have a contracted attorney who advises the council on any motions that would be presented by either the defense counsel or by our counsel. And again, that process is public, and most of the testimony would be either direct testimony or witness statements that were allowed to go in. It's similar to a criminal trial, but it goes through the Administrative Procedures Act. So I'm not completely nuanced with all the legal intricacies of that process, other than how things have looked so far as they've been planned, is that none of it will be the internal investigation itself entered as evidence. It would be documents or the statements of the people affected, the officer themselves, if they choose to, take the stand and testify on their behalf. And it would be mostly direct testimony.
And is it under oath as well?
It is under oath, yes.
And what kind of record of the testimony is there? Is it recorded, I assume, or?
It would be recorded testimony, that's correct.
Other questions by the committee? Representative McCarthy.
Hey, Chris, it's good to see you again. Representative McCarthy. I was wondering if you could speak to how the agenda is set and how the cases are prioritized in terms of the timing.
I can, in general. They're reviewed and accepted by the executive director, then they're put into a queue by date as they come in. How we prioritize them is based on kind of the circumstances of each complaint that comes in. So, for instance, if there's a complaint about unprofessional conduct of an officer, and during that internal affairs investigation or in the process, the officer resigned from the agency or is suspended administratively, that is something that, you know, we look at and say, all right, does this represent a potential danger to the public? Is this a potential, you know, problem for law enforcement as a whole if that person were to have their case delayed a little bit longer before another one takes priority? We try to prioritize them on the severity of the complaint, the active participation of the officer. Are they still an active law enforcement officer? Are they somebody that still could potentially do some other act that might be unprofessional conduct? And we try to prioritize them in the severity of the complaint as they come in.
Thanks.
So one other question about the hearing. That's fairly, technical question. Is it accessible via remote? Is it going to be on some platform, or is it only in person?
No, it's not just in person. It will be available by Teams meeting. That's the platform that we have been using for most of the council hearings. We've talked about, we will certainly do in person because we would like to have in-person hearings, but we will certainly make the opportunity for people to not only review it remotely, but to testify remotely if that needs be.
Yes, Representative Dolan.
Just following up on the prioritization piece of it, I'm curious if somebody's, like if they're in charge of supervising people, if that would bump somebody up at all, if that's considered.
In the area of supervision, I guess it would determine on what level of supervisor they are. So, you know, most agencies are very responsive when a complaint comes in. They do the internal affairs investigation. If it's somebody of rank or not, they typically put them on administrative leave or restrict their duties to what level of supervision they have. Where it becomes concerning is if the complaint is about the agency head themselves, and they're the ones that are essentially running the agency. So we can't make them happen any quicker than they happen. We investigate them as quickly and appropriately as possible. And then we set them for a hearing when that's appropriate. And, we have to rely on agencies, town governments, state-run agencies to take appropriate action when they see misconduct among their employees.
Any other questions? I don't see any, so thank you so very much. I really appreciate it. I guess just one final question. I'm certainly going to be interested in, and I imagine that the committee is going to be interested in seeing the testimony that occurs with the hearing on my understanding, October 17th in the Grismore matter. What's the best way for us to be able to see that, or can we get a connection to a recording afterwards?
We can do either or. If you would like to, you could actually send to me the email addresses of the folks that you'd like to have invited, or if it's just your committee, we can certainly make the invite available through email to your email addresses, and then you can sign on from wherever you like, or you're welcome to attend in the public section here.
And if we're just going to want to actually have access to the recording, is it just audio or is it going to be audio and visual?
I honestly can't answer that for you. I don't know. I would have to check into that and get back to you.
Yeah, if you could do that, that would definitely be handy. And I would think that probably a preference is having access to an audio visual recording as opposed to us attending in some manner. I think that would probably be the best approach for us to see that information.
I will definitely find out how that process works, and I'll send it directly on to you.
All right, I appreciate it. All right, nothing else. Thank you very much. Appreciate
Thank you
it.
for your time.
Meeting or hearing tomorrow on that.
What's that? I think there's the criminal matter tomorrow.
That's the civil.
Yeah, well, yeah, because that was actually done this Avenue.
Yeah, that's my understanding. So this is not till the 17th.
Correct.
All right, so we need to go into executive session, and I'll take a motion to go into executive session to protect the integrity of the investigation that is ongoing. We're going to be hearing from Downs, Rackland, Martin. So
moved.
Seconds. And all in favor, raise your hand. We're in executive session.